What looks like a routine courtroom hearing quickly turns into a series of serious felony admissions, competency rulings, and a shocking aggravated robbery case that even the judge describes as something out of a movie. Stay with this, because every decision in this courtroom carries life-changing consequences.
Okay. Are you Kevin Lee Tran?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictments and the motions?
He does, Judge.
Mr. Tran, in clause number 25, DCCR 0423, you're charged with the second-degree felony offense of assault on a peace officer from March 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
This was in there. And are you pleading guilty because you actually did what they charged you with? Sorry.
Yes.
And then in clause number 25, DCCR 0424, you're charged with the third-degree felony offense of assault on EMS personnel from March 14th of 2025. And how do you plead to that charge?
No contest.
It's that you're either guilty or not guilty. And are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? In those two cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up, please.
Yes.
And Your Honor, I would ask the court to take judicial notice of the letter dated March 12, 2026. Should have thrown it in the first.
In what case?
All of these cases, Your Honor.
Okay, hold on.
Mr. Tran had been evaluated, was incompetent for.
Oh, hold on. Okay. Hold on. Thank you, Mr. Nicholas.
Yes, Your Honor. I should have done it at the onset. Sorry.
Sorry, they're not in together. Okay, here we go. It's okay. I know. I just have to say it out loud. All right. I'm going to take judicial notice also in all of the court's files. And hold on a second. Mr. Tran was evaluated for competency and was found not competent to stand trial back in August of last year, was sent to the John Dunn Behavioral Science Center for competency restoration, received the report from them dated March 12th of 2026 that has the finding that Mr. Tran has attained competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from the defense, Judge.
Not from the state, Your Honor.
Okay. Then at this time, based on that report, I will find that Mr. Tran is competent to stand trial. Okay. So now I've got to go, where was I? All right. So I went through clause number 0423 and 0424. And so, Mr. Tran, did you go over the paperwork on the tablet with Mr. Lewis?
Yes, Your Honor.
And you fully understand it?
Yes.
And you understand, if I follow the agreements that you've made with the district attorney, that you're waiving your right to appeal?
Yes, Your Honor.
State tenders number 1 in each case.
No objection, Judge.
They're admitted in each case. Again, I'm going to find that Mr. Tran is competent to stand trial. Mr. Tran, I'm going to find that you entered your pleas of guilty in each of these cases freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 25, DCCR 0423, find you guilty of assault on a peace officer, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0424, Find sufficient evidence to find you guilty, and at this time finds you guilty of assault on EMS personnel. Sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-37560, I have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the state jail felony offense of theft of property, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, Your Honor.
And Judge, count one is one of the offenses we just pled to. Count two is one that's being dismissed. We could just do count one of these. That's right, Nicole.
1 and 3.
Yes, Your Honor.
Just a second. And then in cause number 21-38780, I also have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the 3rd-degree felony offense of assault family violence by impeding breath or circulation. And that was a 5-year term in prison that was probated for 5 years. Is that also correct?
Yes, Your Honor.
These cases each allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of assault on an EMS personnel, the one that we just went through, from March 14th of 2025. And is that true or not true?
Yes, it's true.
And then count 3 in each case alleges that you committed the new offense of assault on a peace officer from March 14th of 2025, also the other case that we just went through. And is that true or not true?
Yes, Your Honor, it's true.
Did you enter your pleas of true in each of these cases to counts 1 and 3 freely and voluntarily?
Yes. Yes.
And did you plead true to those counts because those counts are actually true?
Yes.
In each of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes.
And do you fully understand them?
Yes, Your Honor.
And again, you understand if I follow these agreements that you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
State tenders number 1 in each of these cases.
No objection.
It's admitted in each of those cases. All right, Mr. Tran, in each of these cases, in cause numbers 21-37560 and 21-38780, I'm going to find that you enter your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true. And 21-37560, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-38780, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in all 4 cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. I have just signed a dismissal in cause number 25 DCCR 0422 as part of that agreement as well. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Good morning. Are you Christian Lazo?
Sí.
And for the record, Ms. Burge has already been sworn in and is going to translate for us, correct, ma'am?
Yes, Judge.
Thank you. Mr. Lazo, in cause number 25, DCCR 1423, was previously in court, entered a plea of guilty to the first degree felony offense of aggravated robbery. The agreement was for a cap of 15 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Have you both had an opportunity to review that report?
I have, Judge.
Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the defense.
Not from the state, Your Honor.
Well, Judge, there is one issue that was brought to my attention this morning by Mr. Alonzo in regards to his criminal history. I think there is a notation there from the federal issue, and according to the report we have that he pled guilty and was sentenced time served. According to Mr. Alonzo, he was granted asylum during that time, and wasn't actually sentenced in that matter.
Is there currently an ICE hold? Can you check, please? Is there, but Mr. Lazo is not here legally, correct?
No.
Okay. Yes.
Okay. Sí, hay hands first, yeah. First, yeah, and us. Una okay, sí, no soldado hands.
All right, Mr. Lewis, you may proceed with argument.
Well, Judge, Mr. Alonzo, he's been pretty straightforward from the beginning of this case of his involvement. He's taken full responsibility, trying to be as cooperative as possible in this matter so the proper parties and everyone can be made whole, especially dealing with the victim and what they lost out on, even to the point where he didn't know the victim would be here, but he did prepare a letter of apology that at some point he would hope been able to read or let them know of. He does understand he does have other holes from different counties that has to be addressed as well. So at this time, he's really just asking the court for as much leniency or mercy as possible as far as going forward to resolve this matter.
Thank you, Mr. Nichols.
Your Honor, I took into account his cooperation and willingness to accept responsibility when I capped it at 15. This is a pretty horrific robbery where they targeted this woman who's sitting right over here. He knocked her to the ground while holding a gun. They stole $80,000 in cash from her business. They've been targeting this woman. They've been following her and planning this for months, Judge. And I know another individual was involved. That case is pending. Mr. Lazo did essentially debrief as to how they got there and what they were doing. And that was taken into consideration when the cap offer was made. But the facts of this case, Judge, I think 15 is more than appropriate. She was terrorized. She was brutalized. She was injured. And had to go through this. She lost items that can't be replaced. Some belonging to her late husband they stole from her. They stole her passport along with this huge amount of cash that was from her business. It was obvious they had targeted and sought her out and followed her, and that this was not just some random occurrence, that it wasn't just a crime of opportunity. They came in from Houston to do this, and they've been planning it for some time, Judge. So I ask the court to assess the full 15.
Anything else?
That's what I'm finished, Judge.
Mr. Lazo, I appreciate your attorney's arguments, asking me for leniency, but any leniency that you, I don't even know if deserve is the right word, but are getting was because of the agreement that your attorney reached with the district attorney for that cap of 15 years. What you two did to Ms. Ordaz is absolutely something, it's out of a movie, scary for a person who is just living their life, trying to run a business. And in my opinion, 15 is really probably not enough, but I understand, and I think she probably feels the same way. I appreciate, and I'm sure everybody, including her, appreciates you taking responsibility so that there wasn't a drawn-out trial, so that everybody involved is going to also have their day in court. And so based on all of that, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery, sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification that shows that this was an agreement I followed, and so you have given up any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and you need to read it carefully. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. And if you guys will have a seat at council table, we will go off the record for a victim impact statement. Okay, so this is 24 DCCR 2330, just trying to get up to speed. Good morning, ma'am. And Ms. Miles was in court and entered pleas of truth to counts 1 through 4 in a motion to revoke unadjudicated probation. On probation for tampering or fabricating with physical evidence, third-degree felony, and I reset the case.
She pled true to counts 1 through 4, not
Right.
true to count 5.
Not true to count 5, which is the count with regard to that she was. So all of these have to do with, most of them have to do with the ISF and the fact that she didn't successfully complete it and was removed from it. And count 5 specifically made the allegation that she was walking around in the quote living room of the dormitory during count time, which was against the rules. We reset it, and I asked for and received the a report, the discharge report from ISF. And so I guess where are we now?
So one of my main concerns is, and I'm not, well, obviously she's just started probation, but there is a history of mental health issues. I don't know if necessarily if Ms. Miles has been on the mental health caseload. There have been several diagnoses that she has. I'm not sure if proper medication may be an issue. I know she recently told me that they have put her back on some type of medication, which I do think has contributed to some of the behaviors. Due to her not being on probation very long and not being at ISF very long, we are asking that she be given another chance to try to make this right to successfully complete the probation. Mainly that was the issue on the motion, was her not completing ISF and adhering to all of the rules and regulations there. So I don't want the court to totally give up on her at this point, but we understand obviously that a person needs to successfully complete ISF when they are ordered.
I mean, what option? And just for the record, if you'll raise your right hand, please, ma'am, do you swear or affirm the testimony you're given this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so what options and what's probation's thought with regard to any type of mental health issues that could be addressed?
Well, prior to her placement at the facility, I did go to the county's corrections facility and speak with Miss Miles. And I told her that upon her completion of the ISF program, that I would have her meet with in Spindletop to have all of those assessments that she would need to see if that she could be accepted onto the mental health initiative caseload. But we didn't make it that far.
I guess the problem is if there are those issues, then those need to be addressed in order for her to be successful wherever, including ISF. So and those evaluations cannot be done while she's in custody at our jail, correct?
I don't know what can be done at the correctional facility, but I do know that I spoke to some members from Tacoma to have it set up to where they could start that process while she was at the facility, at the ISF facility. But due to her, disruptive behavior there, it didn't get very far.
So if we need an evaluation done because the disruptive behavior could potentially be because of mental health issues, then what are my options?
I believe that the staff from Spindletop can go out to the facility and do some type of assessment on it.
I know we've had difficulty getting them to do that.
That's what my understanding is as well.
I've seen them there. I don't.
Yeah.
And I know Ms. Miles has been a Spindletop patient in the past.
You have go and behave if there's an underlying issue without those.
We said we can request the records to see exactly what she was diagnosed and when the last time she was there.
Okay, let's do that.
I want to do that.
We'll do it whenever the next docket is. It's going to be a couple of weeks. We don't have a docket next week, but let's do that so that we can see what the diagnosis was so that we can figure out. I don't want to set Ms. Miles up to fail. I mean, and tell somebody to go and follow all the rules when there's behavioral issue potentially based on mental health. Now, if it's not, and there's just behavioral issues, then that's going to be on you. So it's not going to be an excuse to misbehave and not follow the rules. But if there's truly an issue, I want to know about it and what those issues are, what the diagnosis is, and whether or not that diagnosis would potentially cause some of the issues that have happened. So let's see. We'll get it reset and we'll come back. Okay. Would you make a note that? Good morning. Are you Justine Williams?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Williams, in cause number 26, DCCR 0271, you're charged with the third-degree felony offense of obstruction or retaliation from December 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? That's good. Do you fully understand them? Do you understand those documents? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement. You understand? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williams is not competent?
No, Your Honor.
All right, Ms. Williams, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, sentence you in accordance with that agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff.
Yes.
Thank you. Good morning. Are you Derek Corbin?
Yes, ma'am.
And I'm going to take judicial notice of the court's file in Mr. Corbin's case. It's 25 DCCR 1659. Mr. Corbin was evaluated for competency to stand trial, looks like at the end of January of this year, 2026, by Dr. Rapon. We received that report. The finding in that report is that Mr. Corbin is currently competent to stand trial. Understand that there's some issues, but that he is competent. Is there any other evidence with regard to competency?
Not competent.
Not from state, Your Honor.
All right, then at this time, based on that report, I will find that Mr. Corbin is competent to stand trial. What is the announcement?
Judge, I received some additional medical information in regards to Mr. Corbin from his family
Okay.
that directly relates to this case as far as with the allegations. So I do need to go over that with Mr. Nichols.
Okay.
So I would ask some time so we can try to.
So I'll do one more, just a normal reset
Yes.
to make sure you get that taken care of. Mr. Corbin, we'll just do one more reset. Mr. Lewis will be out there to visit with you once he talks to Mr. Nichols.
Yeah, I'm
Okay.
constipated. I've been in jail. They don't want to send me to the hospital. I was sitting at this kitchen table that night, and the voice is so.
Hang on. So let's not talk about the case. I'll make sure and send a note over to the jail to make sure that you're getting taken care of. Okay.
Okay, I think I got to go to the hospital.
Okay. You can go back with the bailiff. Good morning. Are you Christopher Fair?
Yes, ma'am.
And this is 18-30684. Mr. Fair is on probation for indecency with a child by sexual contact. A first amended motion to revoke probation has been filed. And what is the announcement?
Judge, the motions consist of some new cases that were filed out of Walker County. And basically what happens, once he made bond, then the MTRPs happens, he's been in custody. I'm trying to be in touch with his attorney he has appointed to him there to see if we can try to get something worked out that will take care of both matters together.
Okay.
I think if we can just maybe get one setting, I think I can get that worked out, Judge.
Okay. Any issue?
No, Your Honor.
I'll say, Mr. Fair, I'm just going to do a normal reset. That'll give Mr. Lewis time to get with your attorney over in Walker County, see what they're doing on your cases, get something worked out here, and we'll get it taken care of at the next court date. All right. You can go back with the bailiff.
From multiple guilty pleas to a major robbery sentence, this courtroom session reveals how quickly cases move from procedure to life-altering outcomes. But the real question remains, was justice fully served here, or just legally processed?